Welcome back. Now that we've discussed the pitfalls that await an employer during the hiring process, we can talk about the actual hiring process. Now, we know that legal issues often arise during the hiring process. This is where you're likely to get those discrimination claims from people who were not hired for the job. And the hiring process is divided into three components, three phases. And you should know these both for the test and for your future business career. These three phases are recruitment, information gathering, and selection before employment. And so we're going to be covering each of those three phases in turn. We know that the business manager who neglects the possibility of illegal issues in the hiring process could it wind up exposing your entire company to liability. Talking about negligence claims for disparate impact. Even if you have a screening device that you feel is necessary for the business, you have to be able to establish that there's no other screening device that would do the same thing without the discriminatory impact. So in this lecture, we're going to look at the legal implications of these three aspects of the hiring process. We start with this notion: employers can stumble over legal issues in recruitment. Recruitment is that phase where we are building our applicant pool. We are creating the pool from which we are going to pull those actual candidates, those who move from the pool to employee candidates. The pool is going to exist, and then we're going to apply the screening devices to those in the pool. Now, recruitment is regulated by both statutes and by the common law. We start with this idea that the law gives employers a lot of leeway in connection with their recruitment practices, meaning the law is going to give deference to an employer in knowing what provides the best applicant pool for the employer. That's sort of the viewpoint. Nevertheless, employers may still find trouble if their discrimination is not based on legal factors, but instead is based on membership in a protected class. Remember, employers discriminate all the time. They discriminate against less educated individuals in favor of more educated. They discriminate against less experienced in favor of more experienced. They may discriminate against those with bad attitudes in favor of those with good attitudes. So employers can discriminate, they just can't do it on the basis of membership in a protected class. Now, federal and state statutes govern the recruitment process. What federal statutes govern it? Well, Title VII, obviously, as we've discussed, but also the ADA, the Age Discrimination and Employment Act, the Immigration Reform and Control Act of 1986. All of these statutes govern the recruitment process. But it's not just the statutes, but the common law also regulates recruitment through the law of misrepresentation or fraud. And in fact, because of the common law, employers may become legally responsible to employees for the false statements they make in connection with recruitment. These often come up because of a discussion about job terms, comments involving job terms, or the company's current financial situation, meaning, yeah, we're going to hire you, and then in a year we'll probably promote you to the next level, and in 3 years you'll be a senior manager and you'll be making lots of money. So yes, apply for our job. You know, that's a statement that maybe it's just hyperbole. Maybe it's just like, oh yeah, there's a lot of opportunities for advancement. But for an employee candidate, for someone who's deciding whether to apply for your job or not, whether to not apply for another job, well, those inducements to apply for your job, well, that sets up certain standards of what they are entitled to. So these situations where an employer makes these false or negligent claims about advancement, about the job terms, or about the company's current financial condition. We're doing great. We're going public next year. Everyone who goes to work now is going to make a ton of money. Those are statements that are regulated by the rules against misrepresentation and fraud, those common law rules based on misrepresentation and fraud. Misrepresentation could also occur involving statements about job security or promotions or benefits. On your test, look for those situations where someone is making promises either that they know are not true, or they don't know whether they're true or not, but they want to make them anyway. Now, the scary thing about this for employers like yourself is that those statements, even if they're made by a very junior person who's going to attend their very first career fair as an employer, those statements could be attributable to the company as well and could create liability on the part of the company. In fact, it's not even enough that it's a false statement. If it's a false impression, could also lead to a claim of misrepresentation. So an employer silence could actually constitute misrepresentation if you are silent on an issue. Fraud in recruitment also occurs if the statements are used to discourage potential applicants from pursuing positions. You know, someone that you don't want to hire comes to you and wants to apply, and you say, the company's not doing well, we're not hiring this year, or, we're likely to lay off 10% of our employees in the next few months, but yeah, go ahead and apply. Well, those statements, even those negative statements, could also constitute fraud or misrepresentation. Now, the scary thing in terms of discrimination is that there are very many common recruitment techniques that are not illegal per se, but they could lead to a claim of employment discrimination. For instance, advertisements. That's pretty standard. Well, if you look at advertisements, oftentimes the ads from employers will say XYZ company is an equal opportunity employer. Why are they saying that? Because they don't want you to construe anything in the ad as being aimed at excluding certain individuals. So the language of your advertisement could affect the size of your applicant pool, the makeup of your applicant pool. And so advertisements, which again are a very common means of recruiting employees, depending on the language, could lead to a claim of employment discrimination. Some employers don't advertise. They just rely on word of mouth recruiting. Well, what's the problem with that is that if you already have a racially or ethnically or sexually diverse workplace, then you're probably fine. But if your workplace is not balanced and you rely only on people that are interacting with your employees through word of mouth, then you're probably going to get a lot of applicants that look a lot like your current workforce. So word of mouth recruiting, not bad per se, but certainly could be construed as leading to a discriminatory claim. Nepotism, again, not wrong in itself. Nepotism involves the hiring of family, relatives of your employees that you've already hired. And nepotism can be very beneficial because this person that you're already is working for you has vetted this new candidate. It's the wife or the brother or the daughter or the son of the candidate, of the employee. Nepotism is not wrong, but again, if you have a situation in which you don't have a diverse workplace to start with, odds are that's not going to be fixed by depending on nepotism for your hires. So just something to be careful about. Promoting from within, again, nothing wrong with that. It makes a lot of sense for a lot of employers. You know this person, they've already worked for you, so of course you would consider them first. Only problem is that if your workforce is not diverse, then you are likely hiring from a pool of non-diverse employees. Venue recruiting, if you go to, say you interview at OU and OSU, go to their career fairs, well, you're going to draw from a predominantly white applicant pool because that's who goes there. It's a single-digit percentage of African Americans at OSU or OU. Therefore, not wrong in itself to go to those, but what you want as an employer is to have as big an applicant pool as possible. So therefore, if you're going to OU and OSU, then go to Langston's career fair as well. This is what the difference between affirmative action policies and diversity policies. Policies that are affirmative action are very closely regulated, but diversity policies are much broader. Why? Because all that means is we want the broadest applicant pool possible. And you as employers, when deciding on how you're going to recruit employees, should always focus on that. How do we get as broad an applicant pool as possible? Walk-in applicants, again, depending on where you're located in the city, could have this same issue. These are all screening devices of a sort. When you choose one of these recruitment techniques, then you are choosing to exclude certain individuals. Maybe not on purpose, but that's the way it works. Neutral solicitation as well. Again, none of these wrong by themselves, but you should think about it whenever you engage in any of these recruitment practices. When you collect resumes, understand that as soon as a person applies for a job, as soon as they click that button on the website or send an electronic resume through monster.com or something along those nature, as soon as that resume is sent, that person is entitled to the protection of the law. Meaning, if you are going to collect resumes, then hold on to all of them. If you are going to reject unsolicited resumes, then throw them all away. But don't pick and choose. Don't put some aside, well, maybe I'll consider this person later, and some of them we just eliminate right off the bat. So there are concerns too with the collection of resumes.